All right, we're going to continue with that story and bring in now immigration law expert, Mr. Ashraf Essop. Ashraf, it's a great pleasure to have you with us. A very good afternoon. So please make this arrest make sense to all of us. I mean, the legal immigration as well, in the legal as well as constitutional sense. Please clarify.
Well, I must say there's very little facts that will assist us to clarify the situation. So let's talk about it in general terms, because we'll only know on Monday what the exact facts are. Here's what I understand from what the Department of Home Affairs has released. That there was a declaration of prohibition against the client and that there was some kind of internal appeal. Now, let me just clarify. In terms of Section 8 of the Immigration Act, that deals with whether you declared illegal in the country and what rights you should follow or what steps you should follow in order to file an appeal. So in the event that the decision declaring the pastor prohibited was made by the Director General, then in terms of so many judgments, the applicant can approach court and not the Minister of Home Affairs for a review. Mm-hmm. But if you declare prohibited, access Section 29(1), then you have a right of appeal, or you can make representations for good cause to the Director General not to be declared prohibited. So that in itself is an internal process. Now, in the event that the DG or the minister refuses your request, then you have a right to a judicial review to a judge in the High Court in terms of a piece of legislation known as the Promotion of Administrative Justice Act, or PAJA. Now, under PAJA, you, the applicant, can argue, I have been procedurally unfairly treated, or the decision is substantively unfair. Now, you'd appreciate in the absence of any documentation in front of us, we don't know what happened. But I'm going back to the statement released by the DHA. It appears that this applicant then approached the court for a judicial review. And again, it appears that the judge said, I'm unable to make a decision because I'll be infringing on the separation of powers. Therefore, I think that the minister is in the best position to review such a refusal of not being declared prohibited, and I hand it back to him. Now it appears that the minister has now said, I've made a decision once the court sent it back to me, and I still find that you've not demonstrated good cause to be declared prohibited. Therefore, you are now illegal. So that brings into play other provisions of the Immigration Act, especially Section 49. Mm-hmm. So Section 49(14) says that if you in the Republic in contravention of the Immigration Act and in possession of fraudulent documentation, well, now you're facing a criminal charge for being in the Republic illegally. So what is likely to happen on Monday? It's not that you just found guilty and then deported. On Monday, the client, or the accused in this case, will now have an opportunity of saying to the court, look, I'm not pleading to this. I want to get bail. Bail I'm entitled to even though I'm illegal. I intend fighting the criminal case against me as well. And then an application will have to be made and then determined in the criminal courts regarding his release on bail. That is still a scenario that he will face next week. And then let's say, even if he's released on bail, there's a long time before this criminal case can come to court. Remember that to be found guilty of a crime, there's two elements. There's the intentional element, and then there's the act of being in possession of a fraudulent document. But in many cases, we've seen clients saying, I didn't know that I was in possession of a fraudulent document. I was assisted by A, B, and C. And you've seen a lot of this in the press where even Home Affairs, high ranking Home Affairs officials were facing the full might of the law because they had aided and abetted in the procuring of fraudulent documents for various applicants. So we really don't know at this stage. But I hope that that background has given you a clearer understanding because, like you, I was also confused about what the facts were here. I've heard from the general that he didn't specify that in this case they were fraudulent documents, but he was saying that he's going after all the other people in possession of fraudulent documents, which is the correct approach. You can't be in the republic in possession of illegal documents and feel that you have a right to remain.
Absolutely.
But there's a process of law. There's a whole long, what we call the rule of law, and that has to be respected. And I must say, indeed, has been respected, especially in his case, where the first trial took a period of 8 years. And at the end of the day, the state didn't manage to prove its case. Now you have another set of facts, and this time it relates to his status.
Thank you so much, Ashraf, for that clarity, because I was just, very interested on the side of Home Affairs. I mean, what would have been the normal handling of a foreign national's immigration status as well as ultimate deportation with regards to this particular case specifically? Because remember, when we were told that he was going to be deported immediately after his trial, and they have established that he was initially in the country illegally or had fraudulent documents.
Well, again, only Home Affairs can give you an answer as to why they did or didn't do something. At this stage, it is still very, very unclear. Why has he been charged now with, saying that you prohibited? Oh, the way I understand it, the prohibition was declared some time ago. He went through the process. Now the minister said, look, the courts have handed it back to me. I still find that you haven't shown good cause not to be declared prohibited. Is that the end of the matter? No, you can go back and say, look, the minister hasn't really used his discretion correctly. He's overlooked this, or he's just simply upheld the previous decision. He hasn't applied his mind to A, B, and C. The matter is so unreasonable, or the decision is so unreasonable that a reasonable person couldn't come to that decision. These are all of the tests encompassed in PAJA, administrative justice. And these are the things you could hold the minister's decision to. So I think, it's not over yet. It's still beginning.
Definitely, Ashraf. I wish we had more time. I had so many questions to ask you, but thank you so much for just bringing, some much needed clarity around this, of course, immigration crisis now pertaining to the arrest of Mr. Timothy Omotoso. That was immigration law expert there, Mr. Ashraf Essop there, giving us some much needed insight there on how the immigration of foreign persons should be handled. And we're talking in relation to, of course, Televangelist Timothy Omotoso.